Hey guys, there have been some developments in the case against Richard Allen, who's been charged with the murder of Libby and Abby. And some of the comments online have noted that the DA has chosen to prosecute him under what's called the felony murder statute in Indiana. And that's causing a lot of debate over what does that mean. So let's talk about what felony murder is. Felony murder is it's a legal concept because murder is a felony anyway, right? So if you murder somebody, it's a felony. What are we talking about? Felony murder. Of course, that's felony. They don't have anything else to discuss. That's not what it means. Felony murder, when you're talking to somebody who understands the law, is a concept that you are being held responsible for murdering somebody, even though you're not the person who actually killed them, because you were engaged in some kind of high-level criminal conduct at the time that it occurs. Let me give you kind of a textbook example of this. Let's say you and your buddy are going to rob a bank. You go into the bank, and while you're robbing it, your cohort shoots and kills somebody. That person can be charged with murder because he shot and killed somebody. Let's say it was intentional. You can also be charged with murder under the felony murder rule, that you're going to be held equally responsible because you were engaged in this felony while this death occurred. Let's take it a little bit further and talk about, well, what about the getaway driver? You could be outside the building. Maybe you thought no one was going to get hurt, and yet someone gets shot in the bank, and you're now charged with murder. Okay? Interesting. So that's what felony murder is. It can get a little stranger than that, which it did in Indiana, and we'll talk about that. So in Indiana, they do recognize the principle and the doctrine of felony murder. So let's talk about the seminal case of State versus Palmer. And in that case, there were two people, two bad guys, and one of them was being held by the police, and his friend was trying to get him away from the police and pointed a gun at the police officers. Then told the police officers, you need to let him go. Let him go. So the police officers let this guy go. Then the friend who had been held by the police tells the buddy with the gun, shoot him, talking about the police officer. The officer hears a gun cock. It's pointed at his head. He grabs the barrel and a fight ensues. Gun goes off. The defendant and also his buddy who escaped, they are wrestling with this police officer for the gun, and the bullet goes into the police officer's hand, injures him. He yells to the other officer, shoot him. We don't have a choice. That police officer pulls out his gun, or maybe already had it out, shoots the guy who was being held by the police and kills him. That's what happened. The defendant, in this case, Palmer, was the guy who held the gun and was wrestling with the police and shot the police officer in the hand, but he didn't kill anybody. And neither did his cohort, his buddy he was trying to get away from the police. He didn't kill anybody either. The police officer killed somebody. Now, of course, it was in self-defense. It was completely legitimate, but that's what happened. And they charged Palmer with murder of his friend that he was trying to help get away from the police because of the death occurring during this felony. That case was not a clean case at the Indiana Supreme Court because there were some judges who said, no, this doesn't meet the statute, and others who said it did. And that kind of set the pace for felony murder and how to understand it in Indiana. So let's look at what the court decided. So first, let's see what the statute at question is. The murder statute in Indiana provides under Section 1 or subsection 1, knowingly or intentionally kills another human being. So if somebody pulls out their gun and just shoots somebody without justification and they do it on purpose, that's murder right there, right? Right there in the first subsection. That's pretty clean. You intentionally kill somebody, you knowingly kill them, that's murder. But the next section says kills another human being while committing or attempting to commit arson, burglary, child molesting, product tampering, kidnapping, rape, robbery, human trafficking, promotion of human trafficking, sexual trafficking of a minor, or carjacking before its repeal. So kills another human being while trying to do these things. Now, if you're a normal human being and you read this statute, you think, well, if you kill somebody while you're doing this, maybe if it's not even intentional, because that's covered under the section above, but if you kill somebody while you're robbing them or something like that, maybe you accidentally kill them while you're doing this, then you could be charged for murder here, right? That you're irresponsible, terrible conduct in conducting the felony, even if it was an accident. So maybe I'm carjacking you. Let's see, it says it repealed that. Let's pick something else. Maybe it's a burglary and I come into your house and I got a gun and I'm burglarizing you and I trip and shoot you and it was an accident and it wasn't intentional. I can still be charged for murder because I was engaged in this conduct at the time that the killing occurred. That seems right on the face of it what it says. Now, the minority view in the Supreme Court was that's what it means. And they're saying if you were there and you were an accomplice to a murder, there's a separate statute for that. If you helped commit a murder, there's a separate charge for that, and that's what you should be charged with, or anything else that you personally do. But the minority decision said, or opinion said, you shouldn't be able to be charged for killing someone if you didn't kill someone, because it literally says in the statute, if you kill another human being. But the majority in the Indiana Supreme Court says, no, this is a felony murder doctrine statute as well. It doesn't have intent in it. That's true. But it also means that if someone is killed during the course of one of these type of crimes that are listed, and you're part of it in a way that can contribute to that death, even if you're not the person who killed the person, then you can be held responsible for murder. And that's what they decided in the Palmer case. So in the Palmer case, the guy who was convicted of murder did not shoot the person who died. A police officer shot that person, and he was still held responsible for murder. So that's felony murder. And this doctrine was fine-tuned a little bit later in the Elkhart case. And let's see what they say the limits of felony murder are, because obviously you could get into a situation where it's unfair. A lot of people think it's unfair anyway. I don't, but a lot of people do. I think with certain limits, it is fair. Let's see what the Indiana Supreme Court says. So the Elkhart case involved juveniles who were engaged in burglary. Somebody died, and some of them were charged with murder. And the lawyers advanced the cause that, look, we got to revisit this. We got to go back to Palmer. They got it wrong there. The statute clearly says you kill someone else. So you can't hold somebody liable for felony murder under that statute. And the Supreme Court says, nope, we're still going to do that. That's been the law of the state for quite a while. It's not going to change. And it's not a free-for-all. If you just happen to be there, you can't be convicted under the statute. And what they say is you have to be the immediate cause of the death. You have to have some kind of participation in it. And they use this kind of language. They say that the defendants didn't engage in dangerously violent or threatening conduct. So in the other case, like Palmer, the guy was using a gun to either threaten police officers or actually trying to kill the police officers. So the Supreme Court is saying there's a connection between what triggered the events where the other guy got shot and what this guy was doing. He wasn't a getaway car driver who had no idea what was going on. And in Indiana, maybe that wouldn't be enough, right, for felony murder, because it wasn't enough in the case of these kids who were involved in a burglary who weren't there in any way demonstrating that they were threatening people, because I think they thought there wasn't anybody there, that, yeah, okay, that's all illegal and somebody died and all that. But the point is they couldn't be convicted of murder for that, for, say, their friend getting killed when they weren't actually themselves threatening somebody. That's not excusing what they did or saying they shouldn't go to jail for that stuff. Trust me, that's not the boat that I'm in. But I respect what the Supreme Court is saying here, which is the person who's being charged under felony murder, the way this statute is written, has to be a cause of the person's death. There has to be conduct they're engaging in which contributed to this person getting killed. Because the statute does say kill someone. It doesn't say you happen to be there when someone got killed. It is a pretty generous reading of the statute to use it for felony murder anyway, I think. But that is the law of the state. So that brings us back to this case of Abby and Libby, which is shrouded in secrecy. The probable cause affidavit hasn't been released. Nobody knows why Richard Allen, the guy who's in jail for this under the charges he's got, why he's there. We don't know that. It's all secret right now. The other people who've been suspected in the case, they've been very secretive about what led them to think they might be involved and what leads them to not have arrested them for this. So in some cases, I think it's secret because if you looked at what was in the record, say in the case of the Keegan guy, you would think, yeah, this guy's got to be involved in it. So rather than having the public jump to a conclusion like that, they're trying to keep it under wraps. So what does it mean that he's charged with felony murder and not regular, say, murder? Let's go back to the statute here for a second. So this guy, Richard Allen, if the evidence they had on him was just clean cut, that he intentionally killed another human being knowingly, why not charge him under that? Why charge him under this second provision, which says the person gets killed or you kill them while you're committing one of these other things? Now, I think it's easy for the prosecution to say that one of these other situations was occurring at the time of the deaths. That's clear. These kids, they didn't participate in this voluntarily. I don't think they got to their where they were found voluntarily. What was happening to them wasn't voluntarily, and it certainly implicated some of the things that are in the statute, some of the horrible things that are in the statute. So they've got that. The evidence is gonna support that. I mean, how they even have a recording of part of their abduction in this situation. So they got that. It strikes me, though, what they don't have, maybe, is clear evidence that this guy intentionally killed them or else why not charge it under one? I mean, maybe they do. And from the description of the crime scene that is public, it's hard to believe that it could have been an accident by somebody, right? That seems very hard to believe because they talk about loss of blood and things like that. And 2 people were killed there, murdered there. And so how could it be anything other than intentional? The method of death is going to be obviously intentional. They didn't fall off the bridge and you have to wonder whether it was, whether they got pushed or not. They were murdered where they were found. That's clear. So why not charge this guy with that? Why not charge him with intentionally killing another human being? Because those girls were intentionally killed. And if he were the guy there, then he's the one who did it. And then you have to enter a little bit of a realm of speculation there and say, well, maybe there was more than one person there. Or maybe they're not sure if there was more than one person there. So they could be sure that in their own minds that the evidence says that the guy they've got in jail was there, participated in the crimes against these girls, and maybe not be 100% certain that he's the one who actually physically killed them. That's horrible in itself, right? And to me, from their press conference, they kind of did say, look, we're leaving the tip lines open. We want more information. We want to bring any and everybody who's involved in this to justice. So maybe there's a little bit in their mind open there that, hey, it could have been somebody else there. Right. And we got to get this other person. And then we can figure out, because it still might have been him who did it, which one of the 2 did it, or we might just charge them both under it and let it go at that. So that could be the case. Another thing could be that if they charge him under number 1, right, and then this guy's defense attorney, because we'll talk about that in a minute, comes up with the idea that how do you know he was there by himself? You can't prove he was there by himself. And if you can't prove he was there by himself and you can't prove he used a weapon, then you can't convict him under number 1 because you can't prove he did it. So they could also be potentially heading off a defense there to be able to say, we don't care if he was there with 1 other person or 10 other people. We can prove he was there as the crimes were being committed against these girls, and that's when they died. We can prove that. Okay, we can prove that they died during the course of these other crimes and that he was there and that his conduct contributed to that. So it could be warding off a potential defense if there's maybe a little ambiguity in the final piece of evidence of who used the murder weapon. Maybe the murder weapon's not there. I mean, we know a river was searched and we don't know that anything came of that. I think it probably didn't. So that could be a strategy as well, as to close off this potential defense, even if it's not real. So in my mind, it does indicate that there's a lack of concrete proof that he's actually the person who murdered them, although they may have very good proof that he was there when it occurred. And that's not to say he's not the one who did it, all right? That's to say there could have been someone else there, and they either want to find that person or they want to close off the defense of, well, it could have been somebody other than me, right? It also could be the case they find person number 2 and that person goes, yeah, but he was the one who did it, all right? So I think it's a little bit of a strategy there to get him on the murder charge because they're right there under the same section. But make sure that there's not this loose end out there that's going to help this guy who they say was involved in this all the way up to the point of murder get off on any kind of theory of defense that really shouldn't allow him to get off. That's my perception of it. So I think that's what it means for the felony murder charge in this case. It's very interesting that's charged that way because, again, number 2 doesn't say he didn't kill them. It just says that he might have only been a participant in the situation in which they got killed in a material way. So he could have done it, or he could have been helping to have that occur, is what that says. And they're both murder in that case by Indiana Supreme Court doctrine. So last thing I'll show is the letter from the defendant in this case where he is begging the court, asking to, throwing himself at the mercy of the court, which I'm not sure he needs to do that for this, to get a lawyer, to get legal help. And he had told the court, hey, I'll hire my own lawyer. I don't need one appointed. And then he finds out that it's very expensive. Getting a traffic ticket handled is not going to be the same thing as handling a double homicide case that has national attention, that could be potentially a capital case, could involve other people in it. Those aren't the same, and it's going to be very expensive. And he, I guess, found that out in a material way. And he also talks about how his wife has had to leave the house and she's afraid for her safety and things like that. And that's unfortunate. There's no evidence in public right now of how and why this guy is arrested. They're just not. I mean, there may be rumors or whatever, but they haven't released any evidence that shows what they have against this guy. So if there's ever a case for presuming innocent until guilty, this is it. I don't have to do that. I'm not on the jury or in that courtroom, but I'm just going to be neutral on it. I mean, my assumption is they have some good evidence on this guy, but also until they show it, you can't just take that as a belief. Now, putting that downstream to threatening his family and scaring his family, there isn't anything that I know of, even a rumor, that suggests anybody, his family, has any culpability for this. And so it's rotten to do that to his family. You have no idea how the police found out that this was the guy they needed in the first place. It could have even been somebody in his family that tipped them off. That's speculation as well, right? But hopefully everyone can agree it's wrong to terrorize his family and make them live in fear. Now, he's going to get a lawyer. It's not like it's binding that when he told them I can afford a lawyer that he's not going to be able to get one. He'll get one. They'll get one appointed to him. That could take time. They got to find somebody who can handle this case for him and get cranking on it. He's got a hearing coming up, or at least there is a hearing on whether the probable cause affidavit will remain sealed or not. I don't know what's going to happen in that. I mean, generally they shouldn't be. Generally, the government should let the public know why someone is being held in prison. That's just a concept of limited government. But there are circumstances where it's warranted to have that sealed, at least on a temporary basis. This could be one of them. Again, after reading the interview transcript involved in the other guy who's in prison for charges of inappropriate conduct with children, who was talking to these girls at or around the time they disappeared, and you read his transcript, a reasonable person could conclude he has more involvement with these girls than he's letting on. Whether he was involved in murder or not, that's not to say that, but it is to say that that's a bad story there. And I can see why they don't want that out there, because there are apparently several really bad people capable of this crime in that area. And if you looked at any one of them closely, you think, well, that's got to be the guy. But that's only because you don't realize how many of these guys are out there and how many of these guys they need to go get and put in jail. So I can kind of see it from that standpoint, but yet the defendant still has rights, and so does the public, to know what is our government doing. I mean, this guy, he may want it sealed as well, because it may have some very accurate, damning information about him that he would really wish nobody ever knew. If he did it, he doesn't want anybody to know about it. Whoever did do it doesn't want anybody to know about it, so they might love for everything to stay sealed forever, and that's not going to happen. But we'll know soon whether it'll get to the public eye in the short term or not. And the case has got to move forward at some point. I think it's scheduled for trial not too distant into next year. Of course, that'll probably get moved, et cetera. And there could be further arrest in this case. And this guy, when he talks to his lawyer, may be able to make a deal if there are other people involved, and if he was involved, to rat out who else was involved, so that they can get everybody together and put them behind bars, maybe take the death penalty off the table, because in my other video I talked about how that doesn't really work in that state anyway. But it might be a carrot that at least you could throw out there to get some of these people who were involved in the case, whether it's the guy they got or not, to roll on each other to some degree. So that's the felony murder situation, explained in terms of what the law is for felony murder, and why they might have used it, at least at this point in this case. And I certainly hope they've got the right guy. Bad for him if it is, but if it is him, I'm glad they got him, and bring some justice to his case, because it is just awful. And it became special because they videotaped the guy who was coming toward them, and they got some audio, and you're like, why can't they catch this guy? Maybe they finally have. Happy Veterans Day. Thanks. Bye.